to do Mr. Zanon next?
We can. All right. People of the State of Michigan versus John Michael Zanon, file 226940 SM. Mr. Zanon, I'm going to have you stand at the podium, please.
Sure.
All right, good morning. All right, let's see. The record should reflect that Mr. Zanon appears this morning along with his counsel, Mr. Robert Percola. Prosecution appears by Alex Saminsky. Ms. Danielson, I can see half of you. Ms. Danielson is present in court. Is Mr. McWilliams present there next to you? I can't tell who's next to you.
No, this is my other son.
Okay. Good morning. I see Connie Larson, crime victim witness advocate. Good morning. Concerning the matter, then, we are set for a plea according to my docket. I did receive your letter, Ms. Danielson, concerning your request that the court not accept the plea. I have read it, I've considered it, and I am going to deny your request. I am going to accept the plea agreement that was requested in court. I also read the report that was turned in after our COBS hearing. Ms. Larson, I was a little surprised to see that that didn't come in before the COBS hearing. Can you explain why?
It was given to me right beforehand, and I gave it to Ms. Miller when I got it.
Well, that information obviously would have been important for the court to consider while I was considering the outcome under a COBS plea, and so I have read it in the interim time. Frankly, it has not changed my mind. Obviously, I have grave concerns concerning the physical condition and the resulting injuries to Mr. McWilliams. However, it has not changed the court's basic opinion concerning what we discussed at the COBS hearing, for the record. So it would be important, obviously, in the future, any information should be made available to the court prior to such discussion and not while we're on the record or after the court hearing, which is what happened here. So concerning the matter then, who would state the terms for the record?
The agreement would be as follows. In exchange for an acceptable plea as charged in the complaint, the people would agree to dismiss the bond violations and accompanying civil infractions. Further, the people acknowledged that there was a COBS agreement that was discussed on the record on November 8th, 2022 before this court.
All right, so there are two pending bond violations. What are the other matters that are contemplated being discussed? If you could state those in detail, please, then.
There's a minor in possession civil infraction and a no seatbelt civil infraction that arose from those bond violations.
And you're dismissing both of those?
Correct.
All right, then, Mr. Percola, has Mr. Saminsky correctly stated the terms as you understand them?
Yes, Your Honor. Would the court like to recite the specifics of the COBS agreement, or are you comfortable with the recitation that took place on November 8th?
We have that codified on the record. I'm satisfied with the record that we made. It's all preserved for antiquity. So, no, I don't. All right.
And yes, that is our understanding of the agreement, Your Honor. Thank you.
All right. Mr. Zanon, you've heard the terms placed on the record. You did not participate in the COBS hearing. Are you satisfied with the consultation you had with your attorney concerning what was discussed and placed on the record during that COBS hearing?
Yes, Your Honor.
All right then, Mr. Zanon, have you completed an advice of rights form for today?
Yes, Your Honor.
Do we have that, Ms. Kenzer?
Yes, ma'am.
All right, Mr. Zanon, what is your true legal name, please?
John Michael Zanon II.
All right, the complaint was amended by handwritten delineation back in the beginning. Mr. Szymanski, your complaint indicates such.
It does.
All right. Mr. Zanon, did you understand all of the rights contained in the advice of rights form before you signed it?
Yes, Your Honor.
Mr. Zanon, as such, then, do you understand you have the absolute right to have a jury trial in your case, and in some instances, you have a right to a trial by court?
Yes, Your Honor.
The charge against you in count 1 is aggravated assault. That is a misdemeanor punishable by up to 1 year in jail and or up to a $1,000 fine plus court costs. A consecutive sentence may be imposed under MCL 750.506A if that assault was committed in a place of confinement. Count 2 alleges wearing a mask or a disguise to commit a crime. That is a misdemeanor punishable by up to 90 days in jail and or up to a $500 fine. Likewise, concerning these offenses, there could be immigration consequences. For example, you may have difficulty entering into a foreign country as a result of these convictions. If you're not a citizen of the United States, a conviction may result in removal or deportation from the United States, exclusion from admission to the United States, or the denial of naturalization. Do you understand then the nature of these charges and the maximum penalties, Mr. Zanon?
Yes, Your Honor.
To the charges, what is your plea?
No contest, Your Honor.
And the basis, please?
There's a potential for civil liability, Your Honor.
Does the prosecution object on the basis stated?
No, Your Honor.
All right, Mr. Zanon, before I accept your no contest, well, did he say no contest himself, or did you answer for him?
I answered for him, but
All right, what is your plea, Mr. Zanon?
No contest.
All right, before I accept your no contest, please, I want to make sure you understand the rights you're giving up by pleading no contest. Do you understand then by pleading no contest, there's not going to be trial of any kind?
Yes, Your Honor.
And do you understand that if you had chosen to have a trial instead of pleading no contest, you could have exercised each of the trial rights that are listed in the advice of rights form that you signed and turned into the court?
Yes, Your Honor.
Do you understand the consequence of pleading no contest is that you give up the right to exercise each of the trial rights listed in the form?
Yes, Your Honor.
And you understand the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law?
Yes, Your Honor.
Do you understand a no contest plea is treated the same as a guilty plea for purposes of sentencing?
Yes, Your Honor.
Understanding that and the other things we've gone over here on the record, does it remain your intention to plead no contest?
Yes, Your Honor.
Are you presently on probation or parole to any court?
No, Your Honor.
Outside of the terms placed on the record, has anybody promised you anything in order to get you to plead no contest?
No, Your Honor.
Has anybody forced you or coerced you in any way to get you to plead no contest?
No, Your Honor.
Has anybody told you the courts would be more lenient with you if you pled no contest?
No, Your Honor.
In respect to the matter, do you understand as well that restitution will be part of any sentence concerning this matter?
Yes, Your Honor.
Understanding that and the other things that I've gone over with you, does it remain your intention to plead no contest?
Yes, Your Honor.
Are you pleading no contest freely, voluntarily, and understandingly?
Yes, Your Honor.
All right, counsel, as to the factual basis, how do you wish I make out the factual basis?
Your Honor, we would ask that you review the first amended complaint, Your Honor. I believe it contains the necessary factual information to make out the plea. I would have one further request, Your Honor. It is our intention, as we indicated at the COBS hearing on November 8th, to be requesting of the court treatment under the Holmes Youthful Trainee Act. So I would ask that the court not enter a judgment of conviction if the elements are made out here, and reserve that until the time of sentencing when the court makes its final decision on a request for HIDA.
I told you I'd consider the request for a treatment under HIDA. I did not make a commitment on that on the COBS hearing. I will leave that open for the day of argument on sentencing. I don't have an amended complaint. Is there a first amended complaint?
I thought there was, I don't know if the court simply amended the complaint that was already in the file, in which case it would just be the regular complaint.
What do you mean if the court amended the complaint?
I believe there was a change to the name of the defendant we discussed earlier.
Yes. It was handwritten in by delineation. I don't think your office submitted an amended complaint, did you?
No, then it would just be that complaint that was amended on the record.
Yeah, I believe I recall we did not object to that form of amendment, Your Honor. I don't think it necessarily will affect the factual basis from the complaint that needs to be made out here.
All right, there's only one complaint filed with the court. There was a handwritten delineation on agreement of the parties. So concerning the matter, then I will, if there's no objection from the prosecution, glean the facts as I'm able from the complaint that's been filed as amended by hand delineation. Is that acceptable, Mr. Szymanski?
No objection.
All right, this is Police Agency Report Number M85568-22, CTN 22-22000-283-01. It alleges on or about April 1st, 2022 in Norway Township, Dickinson County, State of Michigan, with the defendant being John Michael Zanon II and the victim being Trenton McWilliams, that Mr. Zanon did make an assault without being armed with a weapon upon Trenton McWilliams and did inflict a serious or aggravated injury upon said person, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Count 2 alleges that Mr. Zanon did intentionally conceal his identity by wearing a mask or other device covering his face for the purpose of facilitating the commission of a crime. The probable cause portion indicates that Mr. Zanon and several co-defendants acted in concert to assault the victim. The group wore masks and gloves to conceal their identities. The victim suffered serious injuries which required medical and dental treatment. Concerning the matter, the court is able to glean from the facts contained in the complaint that in fact this was a completed assault, in that there were actual serious injuries sustained by Mr. McWilliams, which did in fact require medical attention. The reports indicated there were lacerations to Mr. McWilliams' potential concussion and other forms of injury that do constitute serious injury for purposes of the factual basis. In fact, there was a mask which suffices for purposes of count 2 that was worn. I will find that it was intentionally worn by Mr. Zanon in an attempt to conceal his identity. It did cover his face, and he did use it for purposes of facilitating the commission of the crime of aggravated assault. I'm finding that it was a non-consensual assault just by given by the nature of the attack, the vicious attack, given by the fact that this was a pack of people that acted in concert with each other to sustain these injuries. It was a non-consensual touching, and in fact, it was an assault. He was not armed with a weapon. There was injuries to Mr. McWilliams' teeth, broken teeth, which required dental treatment, all which constitute the aggravated assault. And therefore, the court is satisfied with the factual basis as gleaned from the report and supplemented by the medical reports. Are you satisfied with the factual basis, Mr. Szymanski?
I am.
How about you, Mr. Percola?
Yes, I am, Your Honor.
All right, counsel, are either one of you aware of any promises, threats, or inducements in order to get Mr. Zanon to plead no contest that have not been placed on the record at this time, Mr. Percola?
No, I am not, Your Honor.
How about you, Mr. Szymanski?
No, Your Honor.
And does counsel believe the court's complied with the taking of pleas under MCR 6.610 this morning, Mr. Percola?
Yes, Your Honor.
How about you, Mr. Szymanski?
Yes, Your Honor.
All right, Mr. Zanon, I'm going to find that the elements for the no contest plea have been met. I'm also going to find that your plea of no contest this morning has been made freely, voluntarily, and understandingly. I'm going to accept your no contest plea. I'm not making a finding of guilt at this time. We're going to hold that in abeyance until the date of sentencing to determine what, in fact, the consequences are going to be. In regard to the matter, then, we're going to refer you down to probation. They will be making a recommendation about what they feel an appropriate sentence is. And they will also be encompassing in there the amounts of your fines and costs. That'll be gone over with you this morning. They are due at the time of sentencing. What date are we looking at for sentencing, Ms. Kenzer?
January 5th, 2023 at 1:30 p.m.
January 5th, 2023, 1:30 p.m. In the meantime, all of the terms of your bond, Mr. Zanon, remain in place. Do you have a nullie on the bond violations then, Mr. Szymanski?
I will follow up with those, but I'll make the motion on the record, Your Honor.
Is there an objection to the oral motion then, Mr. Percola?
No objection, Your Honor. Thank you.
All right, I'll look forward to the nullie. You can file the requested paperwork, or requisite paperwork, I should say, with the magistrate concerning the civil infraction that you are dismissing. All right, Mr. Zanon, I don't want to hear about any shenanigans between now and January 6th, or you've learned what I do with that. You'll sit yourself right back down in the jail. Am I clear?
Yes, Your Honor.
Your Honor, would you give some consideration to addressing bond? We want to ask the court to review the status of his sheriff's tether, whether or not he could be relieved of that at this point.
Mr. Szymanski, do you wish to be heard on that?
Your Honor, I realize the bond violations are being dismissed, but I would oppose that at this point. The court's free to readdress it, but there have been significant issues with Mr. Zanon and bond prior to this, so I would oppose the request at this point.
I'm going to deny the request at this point as well. Mr. Zanon, for the reasons stated, you are on tether, and that's the way it's going to be until your sentencing.
Thanks very much, Your Honor.
Thank you.